gradually work her up to that, because they believe in their children learning, but like I said, they just dump all that stuff out there, they think you're gonna do it that day.
So is it your testimony that Brandy Lee is doing well in Indiana?
She's working up to that, she's getting comfortable with the environment, we've adjusted the IEP plan where it's not making her frustrated. Now we're starting to see her come home, get off the bus, and this is her normal routine every day. She goes into the dining room, separates herself from everybody. She has access to the school where they tell her what to do with this Chromebook and what needs to be turned on and when it needs to be turned in. And you actually see her in that room doing all this, the requirements that's asked of her through the school. So she is getting comfortable with the movement with that. Because we don't tell her to go in the room. Automatic, she grabs a snack and a water and she goes right into the dining room with her Chromebook.
And that will continue into the 9th grade?
Yes, I believe they get the new Chromebook, and I believe she continues with that during her whole school years now. It's a new thing, and I believe some of the schools already done that out here.
Tell me with respect to the reunification, the counseling, either reunification counseling, you heard Ms. Chris ask this court that be ordered. Back in November when we were in court, I had ordered that she get enrolled in that.
Is she in it and where?
Well, in New Hampshire.
No, I'm saying he said that he was going to get her a counselor. Does she have one currently? Who? Where?
So those aren't my questions, actually.
Well, go ahead.
When we testified at the last hearing, you'd done some research and given me a name of someone that you thought would be appropriate to start that, dealing or doing some therapy with Brandy Lee. And we took down that name, and my order was, let's get her enrolled in that to the extent that insurance will pay for it or whatever. In the meantime, I did have a motion from Miss Chris that said she had contacted that doctor. The doctor indicated he hadn't met with Brandy Lee, and I think either at the referral of Dr.
Yes, he gave me two names that he had suggested because he does not take high-flight conflict cases, which Roland didn't investigate beforehand, before telling you that's who he was going to go to. Nor did they take state insurance. Dr. Roland does not do that. And therefore, he suggested two names for Roland to use. I don't know if he has done that.
Well, that's what I'm asking about. So in my order, I had said if she's not enrolled with Dr. Whalen, then I forget the other names, but they were in my order,
yes,
Dr. Patil or something like that, two other people. So tell me about that, what the status of that is.
Well, eventually, the purpose of that was not for her mental health status, okay? I believe the last time had a court date, last time we had a court date was on the phone. And I do believe I stated before this court that I did have a few different individuals involved. I clarified to the court one of them, and the whole purpose was that because I guess my thought of training of thought behind this was to get a certified counselor that is going to stay before this court, generate a paperwork before this court on what the child is really saying, because this petitioner has said often, as you're aware of, that I'm alienating her, I'm putting her up to this, I'm doing this.
Absolutely.
And that was the realistic of this counseling session.
I understand. Yeah, and you told me that might be the purpose is for.
Okay, the question was, is she in counseling, yes or no?
Ms. Chris,
where?
please. I'm getting to those questions, and I have them. Please don't interrupt. You did indicate at that hearing that the purpose of, in part, for a counselor would be for an independent third party to give an opinion or opine that Brandy Lee, that you weren't influencing her to that extent. That has not happened, correct?
No.
All right, so with respect to the other two doctors, the names that were offered, did you investigate either of those to put her into counseling with?
I prefer just to leave it on hold because I will eventually look for a counselor, but I can tell you if I do find one, Randy Lee is gonna go in there with it not being provided. I can provide it to this court, but I will not provide it to the petitioner. If we're gonna get that kind of disturbing behavior from the petitioner, that's not acceptable.
Way to go, Aaron.
So,
The
the other
child
two
is
counselors,
covered under health insurance, yeah, 100%.
is that what you said?
All of our children are covered under health insurance.
Is it through his employment or is it through the state?
I don't think that's your concern.
Yes, it is. You're supposed to provide financial information according to the rules of discovery as well as mandatory disclosure. So you are obligated by law to provide me with that information. Even though that law has not been enforced, it is the law and you are required to provide that information.
So you're saying all the kids are covered with health insurance and that so Randy has not gone to counseling for either reunification or for any other purpose at this time?
No.
Has she ever?
She's gone to counseling in New
How many
Hampshire,
times
correct?
does the child need to go for, renew, and, I mean, we've done this over and over.
Well,
It's never
No, you've
worked.
never done it.
Tell me
That's
about-
the thing.
Ms. Chris, tell me about the history of the counseling that Randy has had.
She has had, Riverbend, she was ordered to go to Riverbend, and that was part of a reuniting.
No, it wasn't because I wasn't involved, ever.
For her and the petitioner, to reunite them after the petitioner created what she recently did over the National Visitation Center. This has been going on for many years, but we did utilize that for that reason. I mean, how many times do you think we need to go through a session like that? I mean,
Is the concern supposed to be for the child and her well-being? And I don't see this happening. This has been established years ago when she was a toddler that she needed intervention, and I have documentation showing that. And he's, as the custodial parent, has neglected to do that over and over again. He's not even the custodial parent. His wife does all the work. He's told you. He's on the road. He's never home. She is not Randy Lee's custodial parent. Neither is his Nana. And her needs are not being met.
Also, the records do indicate she doesn't have insurance. Her school records.
Yeah, my school record. I can show you her school record. I'd like to submit it into.
I would like to finish up here, and then I'm gonna turn to you for your response to that. So, is there anything
Court
further
order
that
to
you
have
wanna,
Sure.
please don't talk. Is there anything further that you wanna present, Mr. Howe, in support of your relocation, your request to relocate to Indiana? And what I'd like to hear from you is why you believe that it's in Randy Lee's best interest.
just basically explain that all to the court. I mean, that we're gonna change. I think I provided enough for this court, really, I mean, there was other reasons. Now, if the petitioner did not do what she did, and we didn't have other things to do over here, we would have never done that. We would still be here, she would still be visiting. It wasn't like the petitioner behaved herself in this visitation center. Now, if she'd done it for a few years, come request for the courts, I want additional time, then we would have resumed on with that. She would have got outside visits, but she waited until the point where she got thrown out of the place. I just think, I just don't think none of that is safe for the child. That has been a long duration, that's been a long history. It's intervened with our family life, it's intervened with my employment, constant coming here. She don't have to pay for that,
I don't have to
She
pay.
receives funds from
Thousands.
Social Security to stay at home and cause problems. I got a life to live, okay? If the Postal Service is saying, well, it's time to reduce your hours down to 25 hours, I cannot feed my family. It's time for me to move on. And it so happened, it happened at the correct time. The child's been put in a good, safe school, much better school. I got much better employment. There's connection out there. I don't know how much I need to prove to this court. And at the time I did it, I did not do it during visit time. I did it in between the time that she acted not so good and got thrown out there, But on the same token, I'm telling you, the way my thinking is I'm not a lawyer, nor did I call a lawyer and ask them for free information, was that supervised visit to me is when you're supervised visit and then you get thrown out of the place. To me, I believe that the individual does not have any other rights beyond that. And we did move before the court date started.
Without notice.
So everything is safe and productive as far as I'm concerned, on my side of it. You know, the movements have gone very well. Brandy is starting to succeed with the new school system. It's stricter, but I think Brandy will benefit from that.
All right, thank you. All right, Ms. Chris. We've heard his basis. Before you tell me about other things, and I know you may.
I'd like to submit some evidence as well.
Okay, well, in a minute, I'll have you tell me what it is that you want me to look at, but you've just heard Mr. Howe testify as to his reason for why he wants to relocate, and remain there with Brandy Lee. And so, at this point, then it shifts to you to prove to allege in what you want to tell the court that it's why it's not in Brandy Lee's best interest for that relocation to happen. So with
Okay,
that,
for the record, I would like to state that she spent her whole life here in New Hampshire. She has family in New Hampshire. My brother served his country and went to his grave only meeting Brandy Lee twice because of Roland's alienation. My mother's 81 and has only met my daughter twice because of Roland's alienation. He claimed to the court, not just now out loud and before in a previous hearing, as well as in a motion, that Brandy Lee is doing great in school. So I would like to submit evidence of her school records stating otherwise. It says functional self-advocacy. She does not often ask for help on her own or in a general education setting. She's more comfortable asking for help within a small group, special education setting with a resource teacher. She always attempts to do things on her own before asking for assistance, even if she doesn't understand something, because she cannot self-advocate when coercive control is practiced in the home. Also, the present level, Brandy is quiet and hesitant to ask for help within the general education classroom. She is more comfortable asking her resource teacher for assistance with work. Within the speech room, she will ask for help in 4 out of 5 opportunities. She continues to develop and work on strategies to use in the courtroom. It's a Brandy Lee's behind her peers. She's not doing great in school, as he has indicated. And how would he even know? Because he does not attend her IEP meetings, as he stated right here in open court. He is never home. Paula Howe is not her mother, even though she is on the school records, which I'd like to submit into evidence as her mother. Okay, so never once in the whole entire year.
Let's take one thing at a time. If you want to submit that to me.
Yes, I'd like to submit that.
Do we have a copy, or have you seen the IEP report she's talking
We
about?
see it all the time. What I want to say is that there is no comparison of what she submitted in the Hillsborough school, okay?
Those are Hillsborough.
Those are
There's
Kankakee
no
Valley, it's not
comparison.
Hillsborough.
They
That's
are
Indiana. It's Indiana.
equal level.
Okay, wait, do you have one that's not all written on, ma'am? Because this one has all your notes on it, so I'd like to just have one that's a clean copy.
That's,
Well, what else?
Well, a reasonable accommodation, I didn't know that I couldn't make notes on them, and that's the copy that I have. And I can't afford to make 1,000 copies to prove something because Roland left the state without giving notice. So therefore, I'd like to prove my case if that's all right with the court.
Well, the court will accept this copy, but I'm gonna not give any weight, or I'll strike the various comments.
Yes, that's fine, that's fine. Oh, wait, there's more of the school record here, I'm sorry.
Hold on a second.
The entire thing.
also, it does bring up and direct to what Roland stated, that he enrolled all children at the same time under the same insurance. The records themselves state that she was not enrolled with insurance, therefore.
And that's why he doesn't get counseling for it, because she doesn't have health insurance,
Let me
which she's
mark-
court-ordered to have.
I'm gonna mark that petitioner's one, but before you're done, I wanna hear your response, what you were just saying about this. I asked you if you had any objection, you say you see these all the time. This is from Indiana,
Yes.
the IEP.
Yes,
Okay.
but what I want the courts to be aware of is it don't matter where you place the child, not unless you got certain programs for children. Now, schools have gone horrible. you know, they backed up their classrooms to 20, 25 kids, you know, and it is what it is. They basically put it down on the table and here you go home and finish it. That's basically what they do. And there's no comparison with Brandy's
Is
behavior.
there any proof of that?
From
Any
there
kind
to
of
there.
basis to that?
It don't matter what
Testified
school.
to his opinion about it.
It don't matter what school you put the child in. Yeah, it can be in New Hampshire, it can be in Nevada, it can be in Las Vegas, you know?
I'm not really following you. Is the point that either?
I don't know why she's providing that for the courts. I think the purpose of why they're submitting to the court saying, oh, it's going horrible. She shouldn't be here. She should be in New Hampshire.
We're not saying
I'm
the
telling
school's
the
horrible.
courts that there's no difference. I don't care where you put the child, what state you put her in, what school system. We're gonna end up with the same result.
That's why she doesn't need to be in Indiana.
He testified that the IEP was not working at Hillsborough County, therefore it was corrected at Indiana School. If it's been corrected and an established plan has been placed, why can't that established plan be put forward in the household and in the school in New Hampshire?
Okay, all right, so go ahead with.
I also would like to submit a letter from the State of New Hampshire Department of Corrections Division of Field Services. Liz Cloutier has written a letter stating that the domestic violence of Roland Howe, that during these visits when she came to our home when we cohabitated when Brandy was an infant, that Mr. Howe projected a hostile attitude toward this officer and her partner, and then he eventually chose to ignore us. He's talking about my behaviors, but I add aggression, so I would like to point out his aggression as well. Not only the assault on me, but also being aggressive towards my probation officer.
What's the date of that letter?
That is February 18th, 2005.
In regards to...
And it also says, separating herself from Roland Howe was a positive step for Margaret and the beginning of her rehabilitation. So that was never recognized by the court. As a matter of fact, this is missing from the court record. And I don't know why, because it was submitted early on, right with the police report. As a matter of fact, there's a lot of things missing from my docket file that I have here with me today, and my case file has been tampered with on numerous occasions, and I don't appreciate it, and I would like to enter this evidence because it was already part of the record and it's missing.
Okay, so let's call that petitioners too. Do you want to look at it, sir?
In regards to his earlier statements, he stated that we waited 10 years to make it, which was too long. Ignorance of the law, unfortunately, is not an excuse, but unfortunately that what it was. We were under the statement that the court was making us go to the visitation center. We did not know we could file for further thing. It was up to him. He was the custodial parent. Therefore, we didn't wait till we got in trouble. We waited until we were told otherwise, unfortunately, by the courts. Now, as far as the trouble, again, that he keeps mentioning and saying we got thrown out for, I have both police reports right here. Again, after we discovered Anne Louise had given him a letter in error, which he used as perjury to open up with our first case with you, saying that that was the reason we lost visitation, knowing, because I had his signed copy documents from their ledger book, that he had signed those days to not go, not us. He signed them.
And her failure to notify the courts
Hold
and
on,
Louise's.
hold on.
Because that
Still
was
wrote the letter.
required by the handbook of the Greater National Visitation.
Our first case, you told us to go back. They showed us the ledger book. We pointed out the errors. She said, I asked, can we please get a rebuttal letter to prove that we didn't miss these dates? After that date, our entire relationship with the Greater National Visitation Center changed. Not only did it take them almost 6 months to give us the rebuttal letter, but again, they started restricting how many gifts we could give her, not to mention only on birthday and Christmas when there was
We
never.
were bullied. We were.
Hold on, let me finish. I have the original docket of their rules and stipulations, and then the one they updated after this incident. No record of them whatsoever. As far as why the cops were called both incidents, we were starting to be restricted on our freedom of speech. We couldn't, I used the word future speak with Brandy. We couldn't, again, there's tons of incidents throughout the years of her saying, I want to meet Granny, I want to meet my cousins, I want to go to the carnival. I think she was like 10 or 11 and said she'd never gone to the beach.
And she wanted to come to our house and all this, and we weren't even allowed to say, oh, well, maybe someday that'll happen. That was restricted too. First Amendment restricted.
That's what
all
both
over
these
the place.
incidents were. We were being restricted on how we could speak to the child. We called them out on it. Again, my mother's loud, therefore she was seen as aggressive. The cops didn't come because they were called. It says in both police reports, Ann Louise approached them before the visit started and said, be on guard for them, and required them to come forward at her request, not at their own request, her request. And it does mention that both the female officer, because one of them wasn't that bad, he just yelled a lot. The female officer was standing there with her hand on her pistol. Again, this
Intimidating.
is intimidating, and I called her out on it, and then that's what caused the second issue, the next visit. But there had never been any of this, as I think established by our former attorney's partner there, that
Brandy Bouchard.
Brandy Bouchard. None of this was done in front of Brandy. All of this was always done after the visitation. There has never been an established clause, an established reason, I should say, for my mother not to have physical contact with my sister. Yes, there's been aggression shown here as far as emotional turmoil, but it has never been shown towards my
And
sister.
that's directly related to my unjust deprivation of my child since 2004.
Now, there is one notation in the file where Brandy mentioned she's scared of us, and that was in the goodbye letter. Now, that one incident actually coincides with the same incident of us losing outside visitation. After we were told, within seconds of me not being able to after being in the car with her, we pulled right back around because we didn't get 2 feet down the street. They called me and said, hey, you need to be in the car with your mom. We turned right around, got back in the car. Now, again, these visits were held between 9 and 11 in the morning on a Sunday. Nothing is open anywhere on a Sunday. We went to the mall before it closed, hung out in the parking lot for an hour, and then once they opened, we would go around and walk around. No wonder the kid doesn't want to do visits with us. There was nothing to do. It was boring as hell. Even I admit that. But on that specific day, we were running late because there was an issue with the cashier. We had bought a bunch of stuff at the Savers with her. There was an issue with their register, and it caused us to be like 5 minutes late. When I backed out the car, I hit a curb. My mom, why the hell are you driving like that? Why'd you hit the curb? She slapped me in the back of the head. That's all it was. Little like that. It wasn't aggressive, it wasn't a punch,
And
it
it was
wasn't...
because it was like a reflex because I got scared because the car went over the curb.
And again, we were anxious to not be late for the visit. Unfortunately, we were already kind of close to it because of the register issue. That is the only environmentally friendly incident that has ever happened in front of my sister. Now, again, Roland continuously...
I just
sorry.
wanted to say something to that. Now, what they're not explaining to you is now, the history in this case that you have full knowledge of is that the child really doesn't know, okay? So when they...
And we weren't allowed to know her.
Now, just
and it
listen.
was because of him
The only
in this
reason-
court.
The only reason why they were allowed outside the facility, because Mr. Green did not order that. It was me and the facility that agreed to extend parenting time with
How
me
generous.
and them outside of the facility. And it was there then, that incident that they're explaining to this court. Now you have a child that really doesn't know them, that is in the car, that showed great fear. She didn't have a phone, she didn't know how to get out of the car, all of
There
it.
was no issue.
Oh,
We
So
had
I want the courts to realize that piece of it.
we had 2 years of going
I
outside.
submit some evidence from the Greater Nashua Visitation Center because I have a letter from February 4th in 2007 where the program coordinator had concerns about Brandy's continuous diaper rash, being aggressive and out of sorts, sleeping during my visitation time, etc. That she made the court aware of, that she made the guardian ad litem Barbara Griffin aware of, and she made Roland Howe aware of, that were never ever corrected. And I have every single date of every single time this child had a diaper rash and had pain. I also have those 2 letters, conflicting letters that Ann Louise wrote, and I also have my letter that I wrote for an expedited hearing because of the errors that they made with the CEO of this Greater Nashua Supervised Visitation Center, and I would like to enter those into evidence as well.
Well, let me ask you this. I feel like you're not responding to the relocation issue. So
No, this is absolutely everything to do with the relocation issue. You just heard from him that we don't have a relationship with the child, and that's directly related to the behavior of him, his alienation, and being co-signed by officers of this court and the supervised visitation center. So I would like to submit that into evidence.
So whether or not I take that in evidence, because I think some of
It already was, but some of it disappeared out of the case file as usual.
Okay, but we talked about in your presentation, you addressed your request for unsupervised time. And you
Right,
told
because
me-
it's never been founded or any grounds or findings why I shouldn't. And I was deprived, my parental rights have never been terminated, and yet I'm supervised for 2 hours a month, and then that's taken away erroneously, and he's alienating her the whole time, and now I'm being told that they're gonna consider whether I should have supervised visitation. I was never supposed to have it in the first place.
I understand that's your position, and you told me that in the beginning of.
And I can prove it, and I can prove his neglect. He's worried about my mental health, but his mother took care of the child when she was 2004, and his mother has a finding of abuse and neglect against him. He was put in foster care at the age of 15, taken away from her. His brother's a pedophile, he raped his daughter. He was living in the same house as his mother, but this court would rather see my child being taken care of a family of abusers and with a pedophile in it than her own mother with no just finding or cause.
So I understand that you disagree with this court's prior findings and the different judges since 2004.
Right, and as the judge's ruling on it that were recused, breaking the law, the fraud that's happened in this court over and over again. Like I said, because you refuse to hold yourselves accountable, I even have to go to a higher court now.
So, but what I want to hear some testimony on from you is,
And I'm trying to submit evidence to show he's saying that we were so problematic in this visitation center, yet we were there for 10 years. If we were so problematic, certainly it would have revealed itself before a decade. The only reason we were put out of there is because we spotted her error and called her on it, and she began to bully us. And Louise Petrillo. And she's never been held accountable because I asked for an expedited hearing, and that was never granted. They closed the place down so they wouldn't be held accountable for what they'd done.
okay, all right.
And I want it into evidence.
I will.
She'll get it afterwards,
Okay.
please.
So I will take this packet, you wanna look through, sir, what's there, and I'll give it the weight that I think it deserves. Understanding that much of it is either part of this process or the argument that you made, and we're gonna call that number 3.
And in direct response to the relocation and why we're fighting against it, again, the evidence supports itself. You stated already, she doesn't have a relationship with us.
And why is that?
There was an established relationship over years that she, and documented by the professionals.
Time that we had.
By the
Wait.
professionals.
Only one of you can talk. at a
Sorry.
time.
Okay, sorry.
By the professionals of the Greater Nashua Visitation Center. I use that term loosely. Sorry.
For real.
That she was asking about our side of the family, asking to go trick-or-treating, asking to spend holidays with us. She had to correct herself a few times, because anytime we bring it up, hey, you gotta ask Dad, she shut down immediately. Now, again, we're not trying to force her to do something she doesn't want to do. But unfortunately, I feel, and I feel the evidence supports it, that she doesn't have the right frame of mind to make the decision to not want to see her mother when she doesn't even know her mother.
And she's never been given the chance to know us, and it was unjust and unfounded.
And
it's exacerbated by Roland's alienation.
And again, you had stated, again, your first order was that the original order was supposed to go in place of twice a month, 2 Sundays a month, for an hour. As soon as we restarted, Roland did it to 1 Saturday for 2 hours a month. Again, it's the same amount of time, but limited to 1 day rather than 2 individual days. That makes a difference.
And cancels it half the time.
Again, I stated the whole 2015 year, the year that we got the goodbye letter, almost every single visit beforehand was missed by Mr. Howe, including dates around birthdays, holidays.
My birthday always.
All right, hold on.
I just want to alliterate with that, obviously the individuals only tell you what they want, what this court wants.
I have evidence
They
of
We
all
can
days.
document it, we can prove it.
There's a reason why the child does not see her. I don't dictate this, the court's been operating.
The court told you on the first day that you were the adult and we're the child.
It's approved, but what I'm trying to say is that there was, I believe, I don't remember because I don't have the proper documents, but
It's right there in front of you.
what Cameron's talking about is we went it was supposed to be 1 hour for each week. It
No,
did go.
every other week,
Okay,
2 Sundays,
alright,
every
okay.
other Sunday.
I believe the reason for that change was because the individuals, now if you read the original court order, the final court order of 010, it states that they are to notify Roland in a natural visitation of any changes. Me and the child would get up extra early, and then the child became frustrated after when it was a repeated event. We couldn't do nothing for the weekend because we had a visit, okay?
Oh, God forbid she should have.
We
to
wake
spend
up
time with her
early,
mother.
feed her breakfast, get her down there, what would you know? Like several visits were missed, like boom, boom, boom. So eventually the child said, no, I don't wanna go anymore. Now, I'm out in the yard trying to get her to go. But am I to punish the child for not going?
In
Am I
2000,
to force the child to go in there for a visit?
But the court ordered, yes, you are
She's
to
at
bring
that
her.
age, and so the police officer, because that was one of the events that she took out in her control, called the Hillsborough Police Department, I need a welfare check. Welfare officer, the officer come out, and he basically said, how old is she? She's 13. Well, right.
Was this from 2015, what you're talking about? I mean,
Yes.
that wasn't you're saying my original order, that
No.
wouldn't have been mine, but.
no, I'm saying, after we had the original order, you told us to go back after, and you told him it's
No,
your.
that was Susan Carbone that ordered us
Oh,
back
I'm sorry,
to
all
the
right.
visitation
My
center.
apologies. But
Okay.
it was stated that it was his responsibility as the parent to bring the child to a court-ordered
And that was
visit.
said out loud in the hearing. She said, you're letting the child make the decision, and that is not appropriate. You are to bring her to her court-ordered visitation. He did not do that, nor has he ever done it.
Not to mention, he's blowing the child welfare checks out of proportion. Like he said, we did 2 in Indiana. The first one was to establish where his address was, because again, he left without no notice to us or the courts.
Or my former attorney.
Or the former
Nobody.
attorney.
He just up and left.
Yes, the second was of most recent, again, your order to give phone calls. He was not giving the last 4 phone calls. We had a check to make sure they were still there, and he didn't pull a runner yet. That was it. As far as the Hillsborough one, again, we had gotten, it was right before the goodbye letter. He had already missed more than half the visits of 2015. And he says that we missed conflicting. I have the record of every single visit of 2015. We didn't miss 1. He missed 9.
So,
Can you put that into evidence? Can we put that into evidence? Because it just totally conflicts what he's sitting here lying about.
And in that regards, I feel like I'm
And also in 2015, okay, Susan Carbone threatened me with not sending him notice of copies of court documentation. So therefore, a great unnecessary financial burden to me. I have to send everything certified mail. Well, now Roland's refusing service after whining about not getting it. Well, you can't have it both ways, okay? He never sends me notice of anything. No sanctions have ever been put upon him. He's never been threatened with contempt. But yet I have all my motions right here because he refuses service. I sent a package to Brandy. That's been sent back to me. It's sitting at the post office right now, okay? And I have to pay $40 to pick it up because he's not allowing her gifts that you ordered. He's not allowing the phone calls that you ordered. He's still not allowing contact, and this court allows this to go on and on and on.
okay, let me hear from that.
Well, there again, she explains it the way she wants to. She don't explain the whole story.
Well, how is it that if it's not that way?
I asked to hear from him, so let
All
me
right,
hear his
so,
response, please.
It's my understanding that this court has full knowledge of the repeated filings from the petitioner.
What filings?
Inappropriate filings, going through the avenue of the ex parte motions, and then she would check on the box, say, I called them, I sent a letter. Now, what she's telling you, it's months. Now, it's my understanding that I have within 10 days to respond to that motion.
We have to
I don't
accept
get
the
it.
motion in order
This
to
is,
respond
this is
to
the
it.
way I receive them, okay? I don't
No,
want.
this is the way you
Okay.
receive them when you return
That's
them.
This
This is the way you
That's
receive
after
them.
the date
Okay.
of my 10 days.
Lie, we're gonna sit here and listen to
Quiet.
a lie, I got the proof right here.
So, and the other thing too is you recognize that I do work. Okay, my wife does not work. She hasn't caught the postman. It's gone back, yes. What do you want me to do? There ain't anything I can do about that. okay? But as far as what she's talking about, she will. She sends packages like this, okay?
Because
That's
you're
not
supposed to
fun.
have a copy of
That's
everything.
not.
I was threatened with
Exactly.
contempt if I didn't.
But I don't receive it at the appropriate time.
No,
This is
you
the way
receive
I
it
receive
and you send it back. This is the evidence right here. I'd like to submit it into evidence that he's been sent everything and he refused it every single time, which is why I served it to him today in person, because that's the only time I can give it to him.
And I personally made that record. That is an accumulation of all 10 years. I made that over this weekend. He has never been sent anything that big. The contents of these envelopes, which are unsealed after they were returned, are the size of everything he's ever
The
been
only
sent.
one that's open.
Because I pay for half of them with him.
Right, and the only one that's open is from the Jasper County Sheriff's Department, because I had to pay $60 for out-of-state service twice.
Those were your
Okay?
interrogatories
Twice.
you ordered.
The interrogatories, which of course he didn't get because I'm not a lawyer and I didn't fill them out properly, and rules of discovery were never even gone by in this court to even begin with, nor was I given the time to prepare my case, even though I asked you for an extension. So therefore, I made the interrogatories wrong, and they were returned to me by the Jasper County Sheriff's Department. Everything that I send out regarding this case is returned to me. So he has no right to complain about not getting them, because I complied with the court orders and the rules of discovery to send it to him. He's the one who's not in compliance. He's never sent me a copy of anything. This court does its due diligence for him and mails it to me for him. But they don't work for me. They work for him. They don't send him stuff for me. I get threatened with contempt for it instead. So I have to spend my whole Social Security check sending him stuff that he doesn't even take, and now he's going to sit here and cry that he doesn't get it.
Okay, so I want to get back to Brandy Lee, and more that you want to tell me about either his request for a relocation and your objection.
I am against it 100%. He never had permission to leave. He's depriving me of my parental rights, which were not terminated. I have every right to exercise my parental rights. He doesn't get her into counseling. You know, how is she ever supposed to have a relationship with us when he refuses to fix the damage that's been done? He has his wife, you got the records right in front of you, signing as her mother. He has erased me as a parent, even though I have parental rights. He does not acknowledge them, he does not respect them, neither does his wife. She pretends to be me, so does his past girlfriends. He always has the women in his life impersonating me as her mother. Brandy Lee calls Paula Howe mom, not me. Well, how did we get to this point? By alienation by Roland Howe. And now you think you're going to give her the decision whether she wants to see me or not? She was never given the chance, unjustly, to be my daughter. And now is the time to correct that and give her a chance to be my daughter. And that needs to happen right here in New Hampshire.
And as a notation towards Roland's earlier statements that he's not going to give us the therapist, the records of the therapist, or that he's gone out of his way to make sure we don't have records of his address. Unfortunately, because of court orders and my mother's parental rights, he has to. So again, him stating that he's not going to is him just saying he's not going to apply the law.
There's a reason why.
And what is that reason?
Of you guys utilizing the system.
Roland,
Yes,
hold on. Have we ever been to your house, Roland?
Okay.
Has there ever been an incident where we've been to your house and caused an issue?
I didn't even know where he lives half the time. I never knew where Brandy went to school. I don't know where. I never seen a report card. I never